Afternoon, and thank you very much for being here at this special event hosted by the program in public law here at Duke Law School. My name is Neil Siegel, and I co-direct the program in public law. I also teach constitutional law and federal courts. We will discuss two cases in which oral argument was heard this week at the Supreme Court of the United States. The first case, Hollingsworth against Perry. The second, United States against Windsor. And we have with us an all-star cast of characters to give you their professional and personal perspectives on the oral arguments in these cases. First, Roy Englert, who's a partner at Robbins, Russell, Englert, Orsak, Ernter, and Sauber in Washington, D.C. He's an appellate litigator and antitrust lawyer. He's argued 20 cases in the Supreme Court of the United States, with a 21st scheduled for April. That is next month, a preemption case. He's also briefed many other cases in the Supreme Court and briefed and argues many cases in various lower appellate courts. He's a co-founder of his firm, Robbins Russell, in 2001. For more than a decade before that, he was a partner in the D.C. office of Mayor Brown. He was also an assistant at the Solicitor General from 1986 to 1989. He's been watching closely the Supreme Court for a long time. And so if you want to know what the court is likely to do, I think Roy is very well situated to give you an answer. We also have with us today, to Roy's right, Roy's spouse, Dan Betcher. He's a 2000 graduate of the Georgetown University Law Center. He decided not to practice law and returned to school, earning a master's degree in international relations from Yale. He is presently a composer and an entrepreneur. And I have to say that I really like, Roy, your the description of Dan. He says, as a gay libertarian who has a law degree but does not practice, he confounds a lot of stereotypes. So we're not going to keep this just dry and doctrinal. We also have with us Erin Blondell, who's an associate at Robbins Russell, as well as an illustrious graduate of this law school. Erin graduated in 2009, summa cum laude, from Duke Law School. She was an executive editor of the Duke Law Journal, served as a law clerk to the Honorable Sandra Lynch of the U.S. Court of Appeals for the First Circuit, and then as a litigation associate at Wachtell Lipton before becoming an associate at Robbins Russell. So this is how we do it, right? You're a student here and you attend public law events, then you graduate and we bring you back and put you on this side of the table. We also have with us Professor Ernie Young. He's the Alston and Baird, Baird or Bird? Bird. Alston and Bird. Not Alston and Bird, not Big Bird. Professor of law here at Duke Law School. He teaches constitutional law, federal courts, foreign relations law, religious liberty, right, other things as well. He's one of the nation's leading authorities on the constitutional law of federalism, and he's also a very devoted basketball coach, as his son will tell you. So we'll start now with Erin, who will just tee up the cases for us. I distributed a handout. If you don't have, you can pick it up. That just describes briefly what the cases are about, the parties, as well as the questions presented. And Erin as well will speak to this and motivate our conversation.
Thanks, Neil. So the two cases before the court both raised from slightly different perspectives the question about the constitutionality of same-sex marriage and prohibitions on same-sex marriage. The first, Hollingsworth, comes out of California. In 2008, the California Supreme Court ruled that it was unconstitutional under the state constitution to prohibit same-sex marriage. About 6 months later, the voters of California amended the state constitution through a ballot initiative to define marriage as between a man and a woman. California does, however, have a domestic partnership law that grants all of the legal rights of married couples, but couples in California cannot actually be married under that term. Plaintiffs sued in federal district court. It went up to the Ninth Circuit, and then ultimately the Supreme Court granted certiorari on two issues listed in your memo. One is a standing issue, and I'll talk about that first. The state officials in California said that they would continue to enforce Prop 8. That was the name of the proposition. but that they would not defend it in court. So in the district court, the proponents of that initiative intervened and defended the statute, or defended the amendment on the merits. They lost. The plaintiffs won in the district court. So the only people who wanted to appeal at that point were the proponents of the initiative. State officials said, we're done, we're not appealing this decision, we're fine with the district court's ruling. So the Ninth Circuit certified to the California Supreme Court the question of whether under state law, proponents of a ballot initiative have standing to defend that claim, to defend the amendment. The California Supreme Court unanimously held that they did. It explained that the whole point of a ballot initiative is to overcome the reluctance of state officials to pass certain acts or to promote certain policies. And so it said the initiative process would die if state officials could circumvent it by simply refusing to enforce it in court. So the first question before the court is whether now those proponents, and that is who filed the petition for Supreme Court, petition for certiorari in the Supreme Court, whether those proponents have standing. The second issue is whether the Equal Protection Clause of the 14th Amendment prohibits California from banning same-sex marriage as Prop 8 does. In the lower courts, both Due Process Clause and Equal Protection Clause arguments were briefed and argued, and in fact, the plaintiffs before the Supreme Court briefed the Due Process Clause issues despite the language of the certiorari grant. There were 3 litigants that argued before the Supreme Court on Tuesday. The first was the proponents of the initiative. They argued essentially, and I'm sure more people here will have more to talk about, but they argued essentially that it cannot be an equal protection violation and irrational for a state to adopt a definition of marriage that has been enforced for millennia. That's their perspective, that's their historical perspective and their argument. The plaintiffs, the respondents on before the court, took an aggressive, I think, stance. They treated this as a flat, up and down equal protection issue. Is it unconstitutional to prohibit gays from marrying? They did not offer a narrower ground to the court. They simply said this is animus, this is bias, this is not right, and it's not fair, and the Constitution doesn't permit this kind of injustice. The United States appeared, the United States Solicitor General also argued before the court. They argued, I think, what's been called the 8-state solution. They said that states like California,
It's good. Shaking my head.
Okay. I was like,
At the administration, not you.
I was like, do I have something in my teeth? What's going on here?
Ernie's facial expression was on the 9 other faces on Tuesday as well.
Yeah, so they argued, I think, without a lot of receptiveness from the court, that states like California that essentially recognize, they give gay couples all of the rights of marriage but refuse to apply that label, that is the equal protection violation. The United States refused to take a position more broadly on whether, it's just flat out unconstitutional to prohibit gays from marrying, which is somewhat in tension with their position on DOMA, incidentally, which I'm sure we'll talk about. I think the other way to look at this case is the view the Ninth Circuit took, which I think also is not something that the Supreme Court showed much interest in. What the Ninth Circuit held was because California had originally granted gay couples the right to marry and then had taken it away with the ballot initiative, that taking away was the constitutional violation. The other case before the court was Windsor. That's the case that a number of us up here briefed. Windsor raises the question of the constitutionality of a federal statute that purports to define, for all federal purposes, marriage and spouse as referring to a relationship between a man and a woman only. As your handout tells you, there are 3 questions before the court. 2 of them are just standing issues, and the third is the substantive issue. So to give you some procedural background, the United States initially defended DOMA in district courts when lawsuits were filed both within the Second Circuit and within the First Circuit. The United States then said that it would continue to enforce DOMA but would not defend it in court. At that time, a group of members of Congress called the Bipartisan Legal Advisory Group, BLAG, intervened and said that they would be defending the statute, and they hired, Paul Clement, an eminent counsel, to help them defend DOMA because the United States was now agreeing with the plaintiffs on the substance, even though it was, again, continuing to enforce the statute. So the Second Circuit, that's the case before the court is the Second Circuit. What the Second Circuit held first was that, I'm sorry, one more thing on the justiciability. So the questions before the court are, first of all, whether the fact the United States is now agreeing with the plaintiffs in this case removes Article III standing, and whether BLAG has Article III standing to be defending the statute in court. On the substantive issues, the Second Circuit first held that heightened scrutiny applies. As you guys all know from con law, that's still an open question, what level of scrutiny applies to laws seeming to discriminate against gays. The Second Circuit held that heightened scrutiny applies, and under that standard, all the proffered justifications for DOMA fail. The other court that had struck down DOMA previously to the Second Circuit was the First Circuit. I'm going to give a shout out. Ernie's judge, Judge Boudin, wrote the opinion, and my judge was on the panel. They took a slightly different approach. What Judge Boudin wrote is that the Supreme Court's precedents, Romer, Lawrence, and some other, Cleburne and some other precedents, show that when a law disfavors a minority group, and especially a minority group with a history of being kind of mistreated and disfavored, the court applies rational basis plus. It has not actually said intermediate scrutiny applies, but it tends to be more searching than it would for a tax statute or basic economic statute. He also said that another time the court is more searching is when statutes implicate federalism concerns. And DOMA does go into an area that traditionally the states have held, the states have regulated, which is marriage.
Well, that's hotly disputed.
It is, but I think oddly enough, in all arguments, I thought pretty much everyone took as a given that this is typically an area of state regulation. I thought to a surprising degree. But so Judge Boudin said, look, the combination of rational basis plus, which seems to apply in statutes that discriminate against gays, and the heightened concerns that the Supreme Court has shown on federalism issues, together that means that the defenders of DOMA have to show more than simple kind of whatever you guys think, rational basis review. And Judge Boudin held that it failed that rational basis plus standard. So I think the issues before the court include, various justiciability issues, as I've talked about. What level of scrutiny applies? That's still an open question. What interests could justify a ban on gay marriage, and are those interests different for the federal government than for state governments? And quite simply, is it time to recognize the right for gays to marry in this country?
All right, well, thank you very much, Erin. So Erin has described for us what the court is charged with deciding, or at least some subset of the possible questions that the court will decide. And now we'll turn to Roy for his take on what he thinks the court is going to decide, what it won't decide, and how it's going to decide what it's going to decide.
Well, first and foremost, Neil and Ernie, thank you for having Dan and me down here. Neither one of us has ever been to Duke before, for any purpose, not even college basketball.
Well, I have access to tickets, just keep it in mind.
One of the first conversations I had with Ernie Young about this case, I said to Ernie, I'm not a scholar. And Ernie thought I was making a self-deprecating comment. So he said, oh, that's open to debate. And I said, no, Ernie, I'm all about counting to 5 and figuring out tactics. I leave the hard thinking to you guys. And then I read your articles and quote them in my briefs. But I'm all about counting to 5. I was in the courtroom on Tuesday for Hollingsworth v. Perry. Ironically, I was in the courtroom Monday for 2 arguments. I was in the courtroom Tuesday for Hollingsworth v. Perry. The only case heard this week in which I filed a brief was the DOMA case, and I wasn't in the courtroom on Wednesday. But these things happen. Here is what I think will happen in the 2 cases. In Hollingsworth v. Perry, I believe there will be a result that satisfies absolutely no one. I believe the court will decide that there is not standing. I believe the coalition to provide the necessary 5 votes for saying there is not standing will consist of the 4 more liberal justices and Chief Justice Roberts. That coalition may sound familiar if you followed the healthcare case last term. And by the way, if anybody predicts confidently the outcome of a high-profile case like this, remember the healthcare case. That applies to me as much as to anyone else predicting the outcome of this case. But be that as it may, I believe Chief Justice Roberts will be leading, not following, the four liberal justices on standing this time. I happened to argue a case called Sprint v. APCC about 7 years ago, 6.5 years ago, in which I looked Chief Justice Roberts in the eye and talked about Article III standing, and I'm pleased to say he wrote the dissent in that case, but, quoting Bob Dylan, by the way.
Incorrectly, right?
But be that as it may, well, there's a dispute about whether it was correct or incorrect, because there are apparently different versions of Bob Dylan available. Anyway, that man believes very deeply in a very restrictive view of Article III standing. And although not everyone is reading the Hollingsworth v. Perry argument the way I read it, I took his remarks from the bench about the standing of the proponents to be consistent with what I understand to be his very narrow view of Article III standing. The other 8 members of the court, one might uncharitably say, seem to have more opportunistic views of standing. They seem to want to find standing in cases in which they want to reach the merits and want not to find standing in cases in which they don't want to reach the merits. That's an uncharitable description. It's probably not entirely accurate, but it's probably not entirely untrue either. The 4 more liberal justices were quite enamored of what Justice Breyer at one point called the Dellinger Brief, a brief by Professor Walter Dellinger of Duke Law School, also known as Walter Dellinger, head of the appellate practice at O'Melveny and Myers. Walter gets around. Walter did file a brief, the essence of which was to argue it may be fine to grant people other than the executive charged with enforcing the law standing to defend a law whose constitutionality is challenged, but only if the people granted standing have some fiduciary duty to the state. If all they are is private citizens who like the initiative and push for the initiative, they may have more of an actual interest, but in law what they have is called a generalized grievance, that any citizen who doesn't like the law could pursue, and that is not traditionally enough under the Supreme Court's cases, that's Article III standing cases. My guess is the Dellinger view is going to prevail with those 5 votes at least. There might be a 6th vote, I'm guessing, for lack of standing. That would be Justice Kennedy, who was not enamored of the standing argument at oral argument in Hollingsworth v. Perry, but who was enamored of something that I'll tell you here and now is not going to happen, which is dismissing the cases improvidently granted. There are not 5 votes for that, in my opinion. Now, again, remember healthcare. I could easily be wrong, but I don't think there are 5 votes for that. So Justice Kennedy, who clearly does not want to decide on the constitutionality of Proposition 8 one way or another, may join a standing opinion that allows him to be part of the majority not deciding that issue. Or he may not. It only takes 5, not 6. I did not detect Justice Scalia or the other more conservative justices caring much for the standing argument in this case, even though they are traditionally, along with Chief Justice Roberts, the proponents of a rather narrow view of standing. So that's my prediction on Hollingsworth v. Perry. On United States v. Windsor,
Can you just say briefly what that would mean? Because if there's no standing
What
in
it-
the
what
Supreme
it
Court,
means is the
there's no
judge-
standing in the Ninth Circuit either.
correct. That means Judge Walker's opinion in the district court is the final word on this litigation. It doesn't mean it's the final word on Prop 8. It does mean it's the final word on these particular litigants' challenges to Prop 8. So for the named plaintiffs, Judge Walker's ruling is final. For everyone else, it's open to litigation. A district court ruling is not a binding precedent on other district judges. And frankly, it's all in practical terms. This may not be what motivates them, but it's all in practical terms a way of kicking the can down the road. If, as I predict, the court says there's no standing and Judge Walker's opinion stands, there will be more litigation in California. It will work its way through the system for a while. Same-sex marriage presumably will become much more popular in California and elsewhere as people see couples like Dan and me who don't have horns and do have kids. That's a way of postponing the major constitutional confrontation that the Prop 8 case could entail. Somebody had a hand. We're going to have a Q&A period at the end, but if you had a quick question. Okay. Let me turn to Windsor. I think we're all speaking over our allotted time already, so let me move on. I'm going to put this in we and they terms, which is very crude, but I'll do it anyway. I think we win. I think DOMA is struck down as unconstitutional. There, I believe the coalition consists of the 4 more liberal justices plus Justice Kennedy. There is a slim possibility of a 6th or a 7th vote, but don't hold your breath. The 4 liberal justices are widely perceived, and I use the term liberal loosely, it's very reductionist, I don't like to use it, but since I'm going over anyway, the 4 more liberal justices like the equal protection argument, but I think it is my opinion, it's not everybody's opinion, it is my opinion, they'll probably go along with a federalism argument, which is different from the equal protection argument and narrower. The Justice Kagan and Justice Sotomayor showed explicit interest in the federalism argument. Justice Ginsburg and Justice Breyer, well, Justice Breyer did not. Justice Ginsburg's remarks were ambiguous, but I do suspect that there is a chance of actually having a majority opinion, not a plurality, on equal protection, and Justice Kennedy on federalism. The 6th vote in the majority would be Chief Justice Roberts. Chief Justice Roberts asked a question at the very outset of the Solicitor General's argument. If the federal government recognized marriage for all committed same-sex couples and the states did not, the federal government recognized marriage for all committed same-sex couples, even from states in which same-sex marriage is not recognized, would that pose a federalism problem? The Solicitor General answered, no, it would not pose such a problem. Well, that's not surprising. The Solicitor General represents federal power. So he's going to say, hey, no problem, Congress can do anything, the President can do anything unless and until the President tells me he's not going to defend the statute. But, and the Chief Justice's question was widely perceived as hostile to our side and designed to prove that people don't have the courage of their convictions on federalism. Well, guess what? It doesn't matter if Don Verrilli has the courage of his convictions on federalism. It doesn't matter if Robbie Kaplan has the courage of her convictions on federalism. It doesn't even matter if Ernie Young has the courage of his convictions on federalism, though he does. It matters whether John Roberts has the courage of his convictions on federalism. And if John Roberts thinks the right answer to that question is Congress can't do that, then he ought to be the 6th vote on our side, on federalism grounds. Will he be? I don't know. I just don't know. But I don't perceive his question as unrelentingly hostile as some people do. And the possible 7th vote is the justice who never says anything at oral argument, Justice Thomas, who does believe in federalism. I'm going to stop, and I'm going to turn to my spouse. 10 years ago, Dan and I attended an event somewhat like this event at the Georgetown University Law Center the evening of the Lawrence v. Texas argument. And I'll let Dan talk about whether the world is the same or different.
Hi, I am not going to offer any legal opinions because I gave that up. But what I thought I would do is just set the stage a little bit about what a gay couple who's been together for almost 20 years, like we have, has lived with. When Roy and I met in 1995, Bowers was the law of the land. A lot of the states had gay sodomy laws that were not really enforced, but were still there. HIV was a death sentence. There were, the first gay group that ever got invited to the White House was greeted by the Secret Service who were wearing hospital gloves. Things got better from there because they couldn't get much worse. The Defense of Marriage Act, well, they could have got worse, but they continued to get better. The Defense of Marriage Act was also signed into law about the same time that Roy and I were meeting, and it certainly didn't make it any easier on us. We lived in Washington, D.C. at the time, which is a great city to be gay in, even then, and that continues. As time went on, Lawrence came around, and the gay sodomy stuff started to get peeled away, and it made us feel a little bit less suspect in the eyes of the law. And what was interesting, Roy brings up this panel that I did watch. Roy was on it. A guy called Kenji Yoshino was on it, and a woman called Pam Carlin. They're on it if you know who those people are. And it was the first time that anyone started talking about loving as a case that might lead to marriage. And I remember specifically Kenji said that loving leads to marriage, and everyone laughed because it was funny the way he put it, but it was also it also seemed like it would never happen. It just seemed like he was riffing, so that's come and gone. And then in Massachusetts, people started getting married, and in Vermont, people started getting married. And then there were domestic partnership options available in other cities. Roy and I signed a domestic partnership, I think in 2002. in an interior office in the DC Department of Health building on a folding table. And, this is what was meant to be our second choice option. And it wasn't. And the front page of the Washington Post yesterday said something along the lines of, "The future will come, but how soon will it come?" And I think that's what we're looking at right now is society is changing a lot. The faces I'm looking at now are young faces, and all of the statistics say that younger people are broadly in support of us. The people who are deciding this case on the Supreme Court aren't very young, but I'm hoping they can tap into some of that. But ultimately, I think time is on our side, and the future is on our, the future of gay marriage and the future of equality is on our side. I'm not a strident type, but I do know that Roy and I have encountered difficulties that other married couples who are heterosexual have not encountered, and some of those are engendered in the law. And I look forward to progress. And again, like Roy said, we're going to speak in us versus them terms. I'm going to speak in terms of progress. And so that's why I'm here. 20 years ago, it was Larry Kramer screaming and throwing condoms in Catholic churches. And now, even when I was in law school, a group like this, first of all, this panel would have never existed because I went to a Catholic law school. And second of all, the people in the audience would have been strident and angry. And that's not the vibe here today. And, the times are changing. And does the Supreme Court get it right this time? I hope so. But if they don't, time is on our side. So thanks.
All right, thank you, Dan. Okay, Erin, would you like to share with us your thoughts on the oral argument, either what you think the court is likely to do or what you think it ought to do?
Sure. Well, I'm going to defer to Roy's superior knowledge and expertise on this and Dan's superior experience, which I think puts into words plenty of things that I have known my friends and people dear to me to experience. But I will say, I think this is turning out to be a case about incrementalism and whether the court, how far the court is ready to go and whether advocates took the right approach by offering the court a range of solutions. It's turning out, I think, that Justice Kennedy both is not ready to go down in history as the justice who said gays can't marry, but he's not quite ready yet to go down in history as the justice who made the entire nation accept that now. One thing that I take a lot of pride in on our brief was that it was an attempt to give Justice Kennedy an incremental approach. And I think that some of the advocates before the court, including some of the most esteemed advocates in the Supreme Court bar, didn't do the best job they could have presenting an incremental approach. And it may be that Hollingsworth just doesn't offer it, because the two incremental approaches that were sold to the court, or that were offered, one the Ninth Circuit and one by the Solicitor General, pretty much are considered, I think, by most people to be, the Dumb and Dumber approaches to this issue. And I think everybody thinks they're pretty, they're not likely to persuade many people, no matter what your view of these issues are. So perhaps there was no incremental approach, which is perhaps why the court, if it wasn't ready to go here, should have just not granted cert and stuck with Windsor, which does offer a more incremental solution with the federalism argument. But I do think Boies and David Boies and Ted Olson took a very strong position, and it's unclear, we may never know whether that just made Justice Kennedy that much more uncomfortable or not, but I don't know, from a young advocate point of view, that was something that I've been giving a lot of thought to.
Thank you, Erin. Ernie, any thoughts about this case? Do you know anything about jurisdiction, anything about federalism?
Nah, who cares about
This
that?
is like Ernie crack.
What do I talk about first? I can't take it.
So I was reading my Economist magazine last night, and they had a piece on the gay marriage arguments, and they said, it looks like the court is going to decide on a technicality. And I would just say, technicalities are my life. Let me start with a non-technicality, but something kind of small. And I think this built on something Dan said. And I think if you read the transcripts of the argument, it's really remarkable the change that has come in what one can say, and not just what one feels like one can't say, but what one is even inclined to say about gay people. Because no one is making an argument that is remotely similar, for instance, to what Chief Justice Berger said in Bowers versus Hardwick about gay people, that they are not fit to be married, that they are not fit to raise children. None of that is there, and it's almost, the defenders of DOMA are almost apologetic, but it's all about, there's an interest in not making people move too fast, but it's almost like the defenders of DOMA assume that this is the direction of history, and we accept that, but it's all about how fast we're going to go, but there's a lot of respect, I think, there, and I think that's, just one barometer of how far things have come. Now, it's important to win. Winning is good, but I thought that was really striking to me. The second thing I'd say is,
May I say something before you leave that point? In the Hollingsworth v. Perry argument, it was unbelievably striking. Chuck Cooper, a very conservative Republican from Alabama, started his argument by saying this is an agonizingly difficult question and we should leave it to the states. As of the time of Lawrence, conservative Republicans did not think this was an agonizingly difficult question. They thought it was really easy to say whatever we do with gay people, we shouldn't allow them to marry each other. Really easy. It's just 10 years ago. It's amazing.
And
The second thing, and I will shut up, but the second thing is, Justice Sotomayor asked Chuck Cooper, can you think of any area other than marriage in which it's okay to draw a distinction between straight people and gay people, such as employment, in which we don't have a civil rights law? He said, Your Honor, I cannot.
that's just amazing. I agree, but it's amazing. The world has truly changed. The second thing I'll say, and now I am going to go into the technicalities, and that's don't go to sleep on the standing arguments here, because the standing arguments, I think, are independently cert-worthy and independently important, and partly because I love standing, but they go to a lot more than standing, because one thing we're seeing, and I think this is a product of divided government, is a lot broader use of the executive's power not to defend statutes they don't think are constitutional and don't like. Right? So you had the Bush administration issuing all these signing statements that we think this is unconstitutional, we won't defend this aspect of it or whatever. And then you have the Obama administration, saying we're not going to defend DOMA because we think it's so clearly unconstitutional. And it is an agonizingly difficult issue whether this is okay, because on the one hand, every branch has the obligation, it's taken the oath to interpret the Constitution for themselves and ought not to execute, for instance, an unconstitutional law. On the other hand, it's a really great way to repeal a statute that you don't like if you're unwilling to veto it or don't think you can sustain a veto, right? So it's a great end run around Congress, and I think it's part and parcel of both the W. Bush administration's penchant and the Obama administration's penchant to do things without going to Congress, right? And so both standing issues go to that question, because both California and the United States have decided not to defend these laws, even though they were democratically enacted. Right? So the question is, can we put somebody else in the shoes of the government to defend Prop 8, and can somebody else come in and defend the federal statute? And these standing issues go to the heart of that. And I think, I think Roy is probably right about what's going to happen in Perry, and my only, that it will go away on standing grounds, but my only hesitation is, can you talk about the standing issue in Perry without getting into that deeper question about the appropriateness of decisions not to defend? Because what would make decisions not to defend, I think, constitutionally tolerable would be if somebody else could step into the shoes of the and defend the statute. That way, the executive could do its constitutional duty without cutting off the ability of the court to do its duty and the ability, really, of the legislature to pass the laws it wants to pass. And if you don't rule that way on standing, then we have to ask really hard questions about when the executive should be able not to defend something. And I think that's also very deep water. It's a little bit out of the frying pan into the fire. Yeah, you get to avoid ruling on gay marriage. I actually think that's an easier question than this one, but I'm kind of a dweeb about jurisdiction. All right. The other thing I'd say is, just from reading the argument on these jurisdictional questions, I don't think they know what they're going to do. right? I think it's really, especially in Windsor. I mean, the arguments there just didn't get anywhere near the bottom of them, I thought, and people just seem to be scrambling around. And so I'd be particularly leery about making predictions there. And, you know, this is from the guy whose one confident prediction he ever made to a class was they'll never take Bush versus Gore, never. The other thing I want to talk about is a little bit about our brief, and that is the federalism issue in Windsor. And it at the outset, I thought this would be a fun brief to write, and it was people I wanted to work with, but I didn't think it was going to matter because there is no point in just striking down the Defense of Marriage Act on federalism grounds if you have to decide Hollingsworth versus Perry on equal protection grounds. Because if you decide that question, then you're deciding the constitutionality of the Defense of Marriage Act too, I think, on equal protection grounds. And so I thought there were 5 votes to strike down both of them on equal protection grounds, and so our brief was going to be a lark and a chance to write about federalism, and that's awesome. But I didn't think it would matter. But now it looks like we may matter. And according to the oral argument, the guy with the 5 tattooed on his forehead seems to like the federalism argument as a way to resolve these cases. Now, how does that come into an equal protection debate? Because that's what they granted cert on. And I think it comes in 2 ways. One is that when you challenge a statute based on equal protection grounds, the government needs an interest to defend it. Right? At any level of scrutiny, they still need some legitimate interest. And Blagg has said our front and center interest is we have the same interest as a state in defining the tradition and defending the traditional institution of marriage. And that was just a gift to us because it puts the case exactly the way we wanted to frame it, which is you are the federal government. You don't have the same interests of the states. That's an interest the state has because they have a police power to protect the morals of the citizenry. You are a government of limited and enumerated powers, and you only have interests that arise out of those powers, and so you cannot assert that interest, right? And so I think that's one way that it comes in. The other way is that DOMA messes up state law, left and right. People are accustomed to thinking there's federal law over here administered by federal officials using federal money, and there's state law over here administered by state officials using state money, but that is just not true. Most federal programs are administered by state officials, and they're pervasively intertwined with state law. So these Medicaid benefits and stuff like that, administered by state officials. So the people who tell you you can't get your benefits are going to be state officials, even though the state decided that you were married, right? The state official is still going to have to turn you down. And because often the funding for these things is matching funding, state money isn't going to be going to legitimately married couples as well as federal money. So these things are so pervasively intertwined that it just makes it an administrative nightmare for any state that wants to have marriage equality. It makes an absolute nightmare for couples who are married on Tuesdays and Thursdays but not married on Wednesdays and Fridays. I mean, how could you live that way, right? So I think that once you understand that the federal and state law are always bumping up against each other, the federal government is trying to exercise leverage on dissenting states on this issue and make life miserable for states that want to go a different way. And that's why it intrudes on the state's fundamental power to define marriage.
Hey, Ernie, let me say something about the soft underbelly of the federalism argument. Dan and I were married when we were in D.C. today, but when we crossed the bridge into Virginia to go to the National Airport, we ceased to be married. And when we flew to North Carolina, we ceased to be married. So there's going to be some disuniformity.
Absolutely, but I think that's why we have the doctrine of conflict of laws. That's why we have a whole body of law to deal with that question. I think the question is, conflict of laws will pick one jurisdiction that governs your relationship, and we will have to have a debate about which jurisdiction that is. But I think that's a question that we can resolve. But once you know that question, then the answer to that question, then I think you can have a lot more certainty in life. Now, moving from one jurisdiction to another is always going to introduce contradictions. That's federalism. That's what makes federalism so interesting, because it's complicated. But still, I think it's better than having 2 definitions operating on the same people within the same territory, even if they stay particularly completely put. So I think that's a critical issue that's at stake today, and I think we've offered an out to Justice Kennedy, who seems to be a little bit more cautious or hesitant about running the world than he used to be.
Thank you very much, Ernie. Let me say a few words, and then I will open it up. I actually think the standing question in the Prop 8 case is difficult, right? I think there's a lot to the Dellinger argument. I think there's a lot to the argument that we've got this initiative process to allow citizens to do it independently of the machinery of the state government. And when they do it independently in the machinery of state government, and the machinery of state government won't defend the proposition in court, right? I think there's a real argument about undermining the very purpose of the process. If they can't defend it, then whom? Now, Chief Justice Roberts said it may be other people can defend it, like government officials who want to issue marriages licenses, but not to same-sex couples. So it may not be a case in which, if not, then whom? But that question itself is not always decisive. So I think the standing question is actually quite hard. I think and if the court doesn't want to decide the case, I would prefer for them not to mess up standing doctrine just to avoid that. Digging in is a possibility. I agree. It doesn't seem like there's. Now, do you need 5 or 6 to dig? You need 5, which is interesting because you need 4 to grant. And there are Supreme Court clerks who don't know whether it's 5 or 6 to dig. And the logic would tell you 6. Are you going to keep digging and granting, right? But 5 is everything but granting. So they could dig it, but that's going to be embarrassing. Another possibility I want to put on the table, which is you strike down Section 3 of DOMA, and then you vacate and remand for reconsideration in light of the decision in Windsor, and then you deny cert.
And Neil, that's what I always thought they would do. That's actually always what I thought they would do, is I thought they would hold Hollingsworth v. Perry,
Right.
grant Windsor, and after, again, in crude terms, we win Windsor, then I thought they would GVR in Hollingsworth, but.
So, I don't live for standing the way Ernie does, but I do teach this stuff, and at the very least, I would like them not to just do whatever they need to with standing to get there. I actually think it's a difficult question that could have implications in other situations that don't have anything to do with gay rights. In terms of what they should do, I want to explain briefly why I'm glad their brief is out there and why I nonetheless declined to join it and I'm worried about it. Right? I think I'm glad it's out there because if you know what you're doing, you're counting to 5, right? And there's a good chance going in that Kennedy is not going to be ready to decide the big question of the level of scrutiny and the constitutionality of same-sex marriage, and there's a good chance he is going to be sympathetic to federalism objections to Section 3 of DOMA. And so better to have it struck down 4+1, right, than to have it be upheld 5-4 if you want to see it go. Right? But I am concerned about, and if you just assume they're not going to decide Prop 8, then better to have the argument there. But having the argument there, it seems to me, makes it actually harder to decide these cases the way I think they ought to be decided. Right? What are these cases about? I think these cases are first and fundamentally about equal citizenship, or as Justice Ginsburg would put it, equal citizenship stature. Right? There's a reason why slaves weren't allowed to get married. And there's a reason why Section 1 of the 14th Amendment overruled Dred Scott on who counts as a citizenship, right? And what's incidental to national citizenship. Well, it turns out that gay Americans, in my view, are citizens and not slaves.
I thought it was about skim milk.
And so, and so if that's your point of view, that this is actually an equal protection case, and actually a pretty easy equal protection case at this point, then talking about it in terms of federalism can be strategically useful for a wavering justice, but and a federalism disposition of DOMA can be reconciled with an equal protection invalidation, right? Good lawyers can do it, because their argument technically is beyond the scope of the Commerce Clause, beyond the scope of the spending power, beyond the scope of the Necessary and Proper Clause, right? You can still do it, but let me read you from their brief and ask yourself how a justice can subscribe to these propositions and then strike down Prop 8 on equal protection grounds. Wrong brief. In divisive social controversies like the debate over same-sex marriage, federalism lets each state and its citizens decide how to proceed, largely free of national pressure. Federal diversity of outcomes enables the democratic process to accommodate a higher proportion of our citizens' views on the matter than would a uniform national answer. And letting each state decide preserves the exit option for both same-sex couples living in a jurisdiction prohibiting their marriage and strong opponents of the practice who do not wish to live in a state where it is legal. Indeed, exit may be a more effective way for citizens to express their preferences in voting. And it goes on and on about the virtues of federalism, the virtues of diversity, the virtues of local control. How do you subscribe to all that, strike down DOMA, and then say, oh, by the way, one-size-fits-all national solution, all bans on same-sex marriage violate the Equal Protection Clause? Again, you can do it as a technical matter, but in terms of the music of the thing, in terms of what these cases are fundamentally about, it seems to me the more you buy into the federalism argument in one case, the harder it is for you to decide the case on equal protection grounds, right, in the other. And so I think there is a tension there, and a tension that I would resolve in favor of the equality argument, right? If not now, if not for the time being, because I think there is a very strong prudential argument for waiting from the court's point of view, as well from the point of view of proponents of gay marriage. But if you actually think the case is about equality, right, then it's not a cost-free option to engage the federalism argument. I mean, make no mistake, the federalism argument is incidentally sympathetic to gay rights here, but only incidentally. If Congress defined marriage to include same-sex marriages for all purposes under federal law, their argument would say it's beyond the scope of Congress's powers, unless you already decided the gay marriage issue under equal protection, and then Congress could use its Section 5 power to impose that standard. Right? But just the argument they've given about the enumerated powers of Congress, it would strike down, right, a federal definition of marriage that would be very protective of gay rights. So let me stop there. Feel free to allow any of you to respond if you want. If not, we can just open it up.
We should let them.
Okay. Yes.
You mentioned that you think it's an easy equal protection case. Why aren't there 5 justices? Was it my recollection that Anthony Kennedy was the author of the Warren's opinion? Is that correct? So is he just not ready? Is it a political calculation? Or does he really not believe that this area deserves heightened scrutiny?
He's been abducted by aliens.
There's some history here. Civil rights movements, if they are relying on the Constitution, always depend on incrementalism. The two people who have understood that better than anyone else in American history are Thurgood Marshall and Ruth Ginsburg. Thurgood Marshall started with winning the easy cases on racial discrimination, leading up to Brown v. Board of Education. Ruth Ginsburg started by representing men who were discriminated against, because that would allow her to get 9 old white male justices to say, yeah, there's something wrong here. And then eventually she got to be a justice herself and write United States v. Virginia, the VMI case. But the greatest leaders of equality movements we've had in this country in the legal realm, I'm not denigrating Martin Luther King or anybody like that, but the greatest leaders of equality movements we've had in this country in the legal realm understood that you can't get the Supreme Court as an institution to move too fast. You've got to give the court palatable options. Now, would it be a day for celebration if Anthony Kennedy would go whole hog right now? Yes, at least, for us. And has the nation changed more rapidly than I ever in my wildest dreams imagined? Yes. But is a 50-state solution really something the entire country is ready for and that Anthony Kennedy is ready to impose? That one's harder.
I'd also add that I think a lot of people see parallels with potentially prompting a backlash. I can tell you, having done the research for this brief, we're at slightly over majority people support same-sex marriage, but there is a strong minority, 48% of Americans who do not. And I think there is an argument to be said that the way that it's trending, which is 10% each decade become more and more in favor of gay marriage, that in 10 years, Anthony Kennedy will feel a lot more comfortable, or whoever follows him on the court, and would prevent a backlash which would ultimately hurt the cause of gay marriage.
So I think the answer to your question worked back around to Professor Siegel's comments, what I want to just say a word about. And
Surprising.
the first thing is, we aren't here without federalism, right? I mean, this sea change in public opinion doesn't happen without federalism, because I think the nature of this issue is so tied to familiarity, to seeing actual people and disabstracting the question, right? And seeing that they're not that different from you. And I think it is just terribly important that we've had, we haven't had a court ruling on this question, but we have had federalism on this issue for the past decade or so. And we've had different states going different ways. And that's why there are gay couples out there who are married, that people who might have been opposed to gay marriage can look at and say, wow, in Vermont they have gay marriage, and nobody's turned into a pillar of salt, the sky hasn't fallen, and these look like families to us. And that's what's changed people's views. And if we had just from the beginning had to have an up or down vote one way or the other on gay marriage, we never would have gotten to this point, right? And I think you can't say, now that we're at this point, well, now we should turn the federalism switch off, because then that diversity and that opportunity aren't there for the next issue. I also think that federalism has a bias in favor of gay rights because of the nature of the issue and because of the importance of demonstrations on persuading people on this issue. And so I think it's systematically going to benefit this movement. Maybe it would be great to be able to go all the way in one fell swoop, but I think federalism is more likely than not to help the cause of gay rights. And then the last thing I'd say is that at the end of the day, these fundamental rights questions are about national consensus, and we don't have it yet. I mean, I think in academia we have. I was asked by an NPR reporter who was trying to find somebody for a radio interview to be against gay marriage, and I wasn't good. I wasn't anywhere near against it enough. Even though I was talking about federalism, I said I'm pro gay marriage. I can't help you there. And he said, "Well, can you recommend somebody?" And I said, no, I can't think of anybody in the academy who I would recommend. And so we see a consensus perhaps, but it's not a consensus out there. And frankly, if Anthony Kennedy thinks there's not a consensus, there's probably not, because he's got a pretty good sense of this. And so what federalism does is it gives us a way to work out our differences in the absence of consensus and live together in the absence of consensus and build toward a consensus. And it's been doing a great job on this issue. And I understand the impulse to want to go ahead and just get this resolved. And if I were waiting to get married, I would not be happy about an incremental solution. And I absolutely sympathize with that. But this may be the best we can do.
Let me just very quickly, I know we need to get to questions, but let me talk very quickly about people. If you want opponents in the academy, Robbie George at Princeton University, who's kind of a friend of mine, he was my law school classmate, is the leading thinker against same-sex marriage. At a law school, Lynn Wardle at Brigham Young University. I don't know Lynn Wardle, but he is a respectable scholar. On the question of the effects of familiarity with gay couples, the fifth vote in Bowers v. Hardwick, and he actually, we know from the Justice Papers, changed his vote, was Lewis Powell. In later explaining his vote in Bowers v. Hardwick, he said, "I do not believe I've ever met a homosexual." At the time of Bowers, he had had gay male law clerks for 5 consecutive terms. He had one at the time. One of those law clerks he'd had for 5 consecutive terms was Paul Smith, who is gay and who later argued Lawrence v. Texas. But because of the way the world worked in 1986, gay people kept their identity hidden, they kept their sexual orientation hidden, and it was not possible for Lewis Powell to know that he had had all these gay clerks. Times change. Actually, I'll stop there.
I have a question. Assuming that the court doesn't reach the equal protection clause on either case or decided on that and gets rid of the California case and strikes down DOMA on federalism, state rights grounds, what do you think the effect will be? And I'm just wondering if this is part of the incrementalism. So now you have states where gay marriage is legal and states where it's not legal, like we do now, okay? But so if a couple's gay married in New York and DOMA is struck down and, one partner dies and the other partner is getting survivor's benefits because DOMA is gone. What happens when that partner moves to North Carolina? Are the benefits taken away? And after a period of time, isn't this some sort of constitutional problem? I'm just sort of thinking of what the next block might be.
There are a mind-blowing number of permutations.
Yeah.
All of which are addressed in an article called Beyond DOMA, published in the Stanford Law Review, written by Will Bode.
Okay.
These are thorny problems, and Will's ultimate solution is to suggest a federal statute that would resolve these choice of law problems instead of the mess that is choice of law under current doctrine. That is one solution that will not satisfy everybody. It may not satisfy anybody, but it is an approach to these problems. Over the span of time, and it may happen more quickly than I would have originally thought, there will be more and more legislatures and ballot initiatives that are pro-gay marriage, as we saw in November of 2012. And same-sex marriage will be a reality in more and more states without judicial intervention. And as happened in Loving v. Virginia, in which the number of anti-miscegenation laws had been greatly reduced by the time the case reached the court, eventually the court will say what some of us in this room think to be true, which is, duh, of course it's a violation of equal protection of the laws.
But North Carolina passed a constitutional amendment last year, but still-
And my native state of Virginia, Commonwealth of Virginia, has passed a constitutional amendment saying not only do we not recognize same-sex marriages, but any contract that purports to provide the benefits of marriage is invalid. And Dan and I have had practical problems with being in Virginia and trying to say, well, he can sign for me, and oh no, that would be a benefit of marriage.
Katie?
This question is for Aaron and for Professor Young. And before I ask it, you should know that Professor Siegel has called me Miss Federalism before, so I don't think that I'm hostile to federalism or anything like that.
Bless you, my child.
You are such a dweeb.
So my question is, what do you think what is the threat of a backlash, and what would a backlash in your mind look like, and why is that worse than, any potential backlash that might come from a federalist approach, which might consist of getting rid of civil union privileges in places like California and Illinois, the states where I'm from. If people have a backlash against anything, and the federalism option exists for them to scale back privileges that same-sex couples currently enjoy, albeit maybe they're not called marriage. What is the backlash that you're afraid of, and why is it worse in that world?
I don't understand why there would be a backlash against state-created benefits that were created on the assumption that it was up to the state to decide, right? So because the world would remain exactly the same. I mean, maybe you wouldn't have the little, the thrill of giving the finger to the federal government by creating these benefits. But other than that, the world is exactly the same. There is a concern, there wasn't near as much of a, pro-life movement before Roe versus Wade. That decision galvanized that movement in a lot of ways, and you could imagine something similar happening. I don't know. I don't worry a whole lot about that question. That's not why we did it. Or at least that's not why I did it. I'm not sure how likely the backlash is, but I think it's very unlikely that. My understanding of the trend lines in public opinion is that we are very likely to move toward universal recognition within a relatively short period of time. I think the Equal Protection Clause probably does require recognizing same-sex marriage, and I wouldn't, I'm not against that solution at all. I mean, we're basically proposing this as a safety net under that argument. But I don't think we've done anything to undermine that argument, because I think everybody understands that if the 14th Amendment applies and requires this, then federalism bets are off.
Let me just tell you what I worry about. I think the trend lines are clear. If 81% of people under 30 are in favor of same-sex marriage, right? People under 30 are going to live a lot longer than people, say, over 70. But the court doesn't always follow the public precisely. Is it unthinkable that a Republican will be the next president? Is it unthinkable that Paul Ryan will be the next president? Is it unthinkable that he'll be reelected? Is it unthinkable that he'll replace any of the liberal justices? If he replaced Justice Ginsburg or Justice Breyer? Right, so now the court has moved substantially to the right, very likely on the question of same-sex marriage. So how much longer are we waiting, notwithstanding the fact that the country has moved significantly? Right? So I think it's likely the case that time is on the side of those who are in favor of same-sex marriage, but in terms of the public opinion continues to change, and then that's just going to follow ineluctably into the Supreme Court declaring the existence of the right, it's far from clear. There are any number of ways this could play out in terms of who leaves when, right? We're all day to day. But I don't think people who want to see same-sex marriage be the law of the land should just rest on their laurels and say time is on their side and it's just going to happen. The only question is when, unless you mean, sometime in the next 50 or 100 years. Okay, let's, Doug.
Considering Kennedy's big comment, who do you think granted voted to grant certain parity and who voted in Windsor?
Robert, Scalia, Thomas, and Alito.
When I was clerking, you know how on Lexis you can set up an automatic search to run the same search every day and email if you have any new results? So when I was clerking, the Kennedy clerks had one of those set up for opinion by Reinhardt. Right? And that alerted to them that there was something coming into the cert pool, and you just had to be ready to recommend a grant. All right, so yeah, I think.
All right, Professor Levy?
So I have a question from the vantage point of a good liberal here. So you presented an interesting consequentialist argument, right, about why if you're really in favor of gay marriage, you might want to take this federalism move now, or maybe, as Professor Siegel said, you might want to hold off to get the whole thing. But I'm wondering, even beyond this case, suppose you were to say, okay, I want the federalism out now. What is that going to do for the good liberals in other kinds of cases in the next few years? So if I'm a good liberal, and I said, it seems like a good deal now, I'll grab it because I want to count the 5. What should I be worried about outside of gay marriage in the next few years?
So you're asking if we're trying to trick Justice Breyer into endorsing a narrow conception of the necessary and proper clause? Hell yes.
That's the answer.
This is the Church of Federalism. This is all for the good where we're going. So I'm wondering, though, if one has progressive values in mind, what should one be worried about as far as walking on this road?
I mean, I was probably by far the furthest left person on this brief, meaning I'm the only person who votes for Democrats on a regular basis on some issues, I'm sure. But I will say that, first of all, I think we're right on the law. I do think it's correct that the federal government cannot come in and suddenly say, for our purposes, you're not divorced anymore, so have fun with that, which is a point that Ernie made in a blog. But as the child of divorced parents, horrible, just a horrible idea. And I think that has to be right. And so I think that as a good liberal, as someone who really believes in the rule of law and in the ability to go before the court in any kind of case and say, this is what the law is, and the law, we've got to apply that to people and apply it consistently and care about the underlying principles, because often those principles do promote justice for others. You want to be able to say that with a straight face, I think. And I really think that in this question, in this area, it really is wrong for the federal government to step in and start deciding for itself for the first time ever who is married. And so that was what made it easy for me to write. And, I've written things that I don't really believe in.
Not at our firm.
Never. But I've written things where it's like, okay, well that's the best argument for the client, so I'm going to go for that. This was something that I actually thought was right as a matter of law, and you've got to, you're a lawyer first, and you've got to put that first, in my opinion.
Very quickly, if I may, Neil, the scholars will correct me if I'm wrong, but I believe the laboratory of the states metaphor began with Justice Brandeis. Definitely progressive. And it is only in the post-Brown v. Board of Education era that we are scared of states' rights as an illiberal notion.
I would just direct you to the brief and see what it says about the scope of the necessary and proper clause, right? And I think they would say, I think the progressive you describe would find it substantially narrower in 3 independent ways than any progressive you describe would be prepared to endorse. Right, so it's taking what the chief and the conservatives in dissent said in NFIB, the healthcare case, and running with it. Necessary doesn't mean convenient or useful, it means plainly adapted. Proper is an independent limit that has real teeth, right? What was the third one?
Big powers, little powers.
Big powers, little powers, right? Great substantive and independent power, that language in McCulloch that disappears and reappears. All right, in NFIB, which the brief describes as always having been the law. It's that kind of stuff.
I think we're entering a period where progressives may need to start thinking about federalism a lot, because, all these attitudes come from the story of race, right? But all the other issues, I think there is, and that's been, I accept the Reconstruction amendments. I think they largely federalized those questions. And I think on most of the other issues, it is very hard to predict whether the states are going to be more liberal or more conservative, or whether they'll go in both directions. This is an issue where they went in both directions. They actually went a strong majority in the conservative direction, but it's the freedom to move in both directions actually still had a substantially liberal impact, because it was what was necessary was just a few examples to show what would happen. But I think if I'm a progressive and I want governmental reform, And I have to ask, at what level of government am I likely to be able to try out my policy ideas and make meaningful reforms? I look at Congress, and I see they're unable to do anything, and have been for some time. And I look at the states, and I see on issue after issue, global warming, tort reform, state debt, over and over, immigration in both directions, any number of safety reforms. I see over and over the states are adopting interesting and oftentimes progressive positions, and they can because 70% of the states have unitary government rather than divided government. They can actually get things through and try them out.
Sort of like immigration, abortion,
Well,
contraception,
think
the
about
states are just...
think about New York on the question of
all we
immigration,
need to
and
do-
all the states that have rejected the Obama administration's safe communities.
All we have to do is have a
right?
majority of the nation be reflected in a majority of the House, and then so many of the problems Ermi has just identified go away.
Yeah, okay. Yeah, we can dream, can't we? But I think for the present moment, the reason why the national government is so much more trusted by liberals was there was a period in the 30s and the 60s when the states were unable to cope with the problems facing society. I would submit that we are in a period where the federal government is unable to cope with the problems facing society, and the states are the only people offering meaningful solutions. And progressives ought to think about that.
You see what the North Carolina legislature is doing.
Okay, yes.
I was wondering, could you speak to the standard, you mentioned at the beginning the standard of review, whether it's rational basis or rational basis plus. Could you speak a little bit more to that? What they're going to do with that?
I think they still don't know. I think we're back, we're still where we were.
Well, if they do what I predict, they don't reach it in Hollingsworth v. Perry because it goes off on standing, at least the majority opinion, and I assume the dissent confines itself to standing and doesn't talk about what the result would have been if there had been standing. And in DOMA, I suspect one of two things happens. I suspect either 5 justices sign on to a single opinion about federalism, but there is a concurring opinion about equal protection suggesting heightened scrutiny, or there's a plurality opinion suggesting heightened scrutiny, and Kennedy cast the decisive vote on federalism grounds. I suspect it's one of those two things.
What are the arguments on either side for heightened scrutiny or not?
Well, I'm actually going to let the scholars tackle that one.
The typical arguments are, a history of discrimination, right, and poor treatment at the hands of the majority, whether the classification is relevant to any kind of, right, socially relevant purpose, or is it irrelevant? What are the other?
Well, the John Roberts.
Immutability or distinctiveness. It's not just, can you control it as a choice? I mean, religion is mutable, but it's also, right, immutable for constitutional purposes, right? So it's that consideration. There's a fourth.
Political powerlessness.
Right. So that's what the Chief's argument's about, political powerlessness, and are they are they powerful? Are they not? Which was, a very interesting set of, are white plaintiffs in equal protection cases politically powerlessness? Is the NRA politically powerlessness? Right, politically powerless. So I mean, I think on the one hand, you don't want to say there's a sea change, everyone's behind gay rights, and then say, but they're politically powerless, right? So the Chief does have a point, but at the same time, where he was going with that, which was the reason why 80% of people under 30 believe in gay marriage is because of the political power of the gay rights lobby, as opposed to what happens when people aren't terrified about coming out of the closet, right? That seems to me to be more likely what's going on.
I think the best way to think about political powerlessness is this group prevented from forming coalitions in the political process by prejudice with groups that would otherwise be their natural allies? And I think the best evidence that they are is that it seems to me that we have a large group of gay people who are really pushing for marriage and to strengthen marriage and affirming the importance of marriage. In the rest of the society, we have a huge problem with marriage in decline, right? And social conservatives are really worried about that. And it seems like there's a natural alliance between those people and people who are pressing for same-sex marriage. They care about marriage for exactly the same reasons, and yet that coalition will not happen. Why? Because of prejudice. It's just like poor white people in the South under Jim Crow, whose all of their economic interests were exactly the same as the black people that they were helping to oppress. And yet they're not forming a coalition because of racial prejudice. And that is the sort of political dysfunction, I think, that the Equal Protection Clause is meant to get at. And so if you think of it that way, I mean, I think the right answer here is heightened scrutiny. I don't know if the court is quite ready to go there. It's never been clear whether these 4 criteria are just a test, and if you check off all the boxes, then you win, or whether I think there's a lot, more going on underneath.
That very interesting story about powerlessness, I don't think that would explain heightened scrutiny for gender, right? So I don't. So again, these are criteria, and what's independent, what's necessary, and what's sufficient. What you're saying, right, is a theme in the cases, but there are also circumstances in which you have heightened scrutiny in which it doesn't seem to be operating. But those are the kinds of criteria. And what's the best argument on the other side? It's something about how long it's been one way, history, tradition, deference, democracy.
Also just that they haven't recognized heightened scrutiny in a very long time, and they may be concerned about the impact on other cases and other groups.
Yeah.
After Brown v. Board of Education, Herbert Wexler wrote a famous article called Toward Neutral Principles of Constitutional Law. And his basic argument at the time was Brown is illegitimate because you cannot reach that result applying neutral principles. Well, obviously, everybody canonizes and lionizes the Brown decision now. But also, there's been a fight for a long time about whether judges are just imposing their own policy preferences or following neutral principles. So these indeterminate 4-part tests are a quest for neutral principles so that judges aren't just following their own values in the Equal Protection Clause. But at the end of the day, what's the reality of Equal Protection Clause litigation? We protect groups if we think it's not fair to discriminate against them.
Yes, we'll take a
Ernie frowns.
few more questions.
Can you just engage Blagg's argument against federalism that the 1,100 instances of marriage is purely definitional, and the 1,100 instances are within a Article 1, Section 8 enumerated power each time?
With pleasure.
So,
It's our brief.
I mean, we make a variety of arguments. There is no definitions power in the Constitution. So if they're going to define these terms, it has to be necessary and proper to whatever they're doing in these terms. And our position is basically, you can define a term that's used in federal law if that furthers the purpose of some federal statute. So for instance, the immigration law excludes certain marriages from consideration. There's a rule that if you're married to somebody, you can enter the country, but your marriage doesn't count if it's entered into solely for the purpose of immigrating, right? And so it's easy to see how making a choice about marriage furthers the immigration purpose of that statute. And then there may be all sorts of situations in which, in order to make the ERISA statute run right or the tax code run right, you have to make some qualifications to the otherwise state definitions that you would accept. What we're saying is that you have to make those judgments, and you have to defend them in terms of the individual statutes. And if you simply apply to 1,100 statutes at once without explaining how any of them requires this definition or how this definition helps the implementation of any of them, and then you call the statute the Defense of Marriage Act, not the Make ERISA Work Better statute, right? Then you've done something else. And what you've done is you've exercised a great power, not an incidental power. You have exercised the power to define family status, which has always been reserved to the states. So you cannot be plainly adapted to 1,100 statutes at once, particularly if you've never even talked about the question. Now, there's also a fallback position that I think we win on even if you don't buy that, and that is you can have your federal definition, right? But when somebody challenges that under the Equal Protection Clause, you have to come forward with a federal interest. And you don't have the same interests at the federal level that the state has at the state level. You don't have a police power interest in protecting the morals of the citizenry. So maybe you can defend your definition based on it's going to save us money or something, but the one interest you absolutely cannot assert is the one interest that Blagg led with, which is we have the same right to define marriage that a state does.
Yeah. Hey, Professor, I caught you. You said you attack a federal statute under the Equal Protection Clause. You can't do that.
That's true.
Remember that on the bar exam.
Yeah, and I just add that I think it's very clear that Congress was not thinking about, the point of the statute, the way it's written, the way it's titled, the preamble was like to protect and defend marriage. The point of this was to say, and the legislative history could not be clear on this. It ran the gamut in terms of views on gays from the benign to the wow, you're going down in history embarrassingly, buddy. But it was very clear that the whole point of the statute, the way it's written, everything, was to take a policy position on gay marriage. It was not to further, and in some cases, I found there are statutes where, for federal judges, when they do recusals, and the future clerks in this room will learn this, you have to factor in stock ownership of the judge's spouse, because it's perceived that if a spouse has ownership, really the couple does, because that's how ownership works in a marriage. Not true for gay judges. So and it's true for federal members of Congress. So you can, I know Barney Frank is out of Congress now, but you could bribe him via his spouse in a way that you couldn't the spouses of other members of Congress. The point was not, it was just to say, Barney Frank, we don't like your marriage. It was not to say, no, go ahead and bribe gay members of Congress. I just thought that was absurd.
The argument on the other side, and here I have a lot of sympathy for Blagg's argument, is that Congress has very broad power to define the terms in its statutes however it wants, and it doesn't matter if it goes statute by statute. It can do it all at one time, whether they define narrowly or broadly. Each statute, right, can be, because all the limits you're imposing on the necessary and proper clause I don't think are there and haven't been there until NFIB. Right, limits about, well, it's necessary but it's not proper, or that it's plainly adapted doesn't mean rational basis, even though it met that up until last year.
Versus Maryland.
Yeah, but think about, you're quoting, that's right, and you're ignoring its structural logic and everything else it did. You say the Bank of the United States, which was so controversial in the Constitutional Convention that the framers wouldn't even bring it to a vote, that you're endorsing is not a great substantive and independent power, but merely incidental, right? You're saying McCulloch is right about that. Right, even though it was explicitly thought about. That's not substantive and independent, but a federal view about marriage is. This distinction between what's substantive and independent, what's incidental, it means nothing, and so it means everything. What about deportation power? What about executing people for violating federal criminal laws? That's all incidental? Really? Mm-hmm. Or is that, okay, because we've done it that way, right?
No, because executions deter commissions of the crime that Congress has the power to prevent, because the bank facilitates the specifically identified in the opinion powers that Congress is exercising. You're coining money, raising taxes, you're raising an army, all of these things. There's an explanation of how doing this facilitates that.
But if you perform the originalist inquiry, they told you it was so controversial, it was so great, substantive, and independent that they wouldn't even vote on it.
It's not a popularity contest. It's a logical relationship.
The logical relationship is that requiring people to buy health care is a means to the end of regulating insurance without blowing up insurance markets. The logical relationship here is we're defining marriage for various purposes, and we're telling you what it means.
Now, look, I think the healthcare case on this that's hard. Okay, and I'm not sure you're not right about.
I'm not sure you're not right. This is the closest we are going to ever be to married.
This is an easier case than that.
Okay. Yes.
I understand the strategy of federalism and using that because gay marriage is controversial, but in the sense that there apparently are people out there. But I just don't understand that. I guess I really do let my personal opinions sway me more, and I find myself agreeing with Professor Siegel on this point. Why don't we just go with the equal protection argument? And Aaron, what you were saying earlier, that Justice Kennedy doesn't want to go down in history as being the justice that says no to gay marriage. So, I mean, is there, other than the backlash, I guess I'm getting back to the question I was asked earlier, other than the backlash, what is the risk, what is the worst possible thing that Justice Kennedy could do then if he wouldn't agree with the equal protection argument and felt like it was too soon to bring that?
He could decide to vote with the conservatives. He could decide that that presented with two bad alternatives, the worst alternative is imposing gay marriage when people aren't ready for it, and you lose and you lose big. And to be clear, there were plenty of briefs giving the court the equal protection option. I mean, it's not like this wasn't thoroughly briefed, argued, presented. It's our brief was just one of gobs of briefs before the court, and ours was unusual, frankly, in that it presented, I think, a narrower option that was not facially stupid. So I think, it was there for them. It's not like we said, don't, you can't rule that way. We just said, look, if you're not ready to go there, but, you're really uncomfortable with this, here's an out for you.
I said earlier the terms liberal and conservative are reductionist, and they are. But in those reductionist terms, we have a 5-justice conservative majority on the Supreme Court, and we're asking this court to recognize a new level of scrutiny and a new constitutional right, and to do it on something people feel passionately about, and rightly so, namely marriage. Especially after the healthcare decision last term, not the outcome on the tax power, but the way they voted on the Commerce Clause power, it makes a certain amount of sense for a hired gun tactician like me to say, maybe there aren't 5 votes. Whatever the right answer is, and obviously I'm married to a man. I think I know what the right answer is. But regardless of what the right answer is, I want to get 5 votes from this particular court.
Here's the other thing. I think you're insufficiently appreciative of the glories of federalism. This is not the only issue that's coming down the pike. There are lots of issues on which people disagree. We have not reached social consensus. They are tremendously important to individuals, to their sense of liberty and self-worth and equal citizenship. But we don't have the consensus that would allow us to just take one position as a matter of constitutional law. I think there are issue after issue after issue is coming down the pike, and the way those things get worked out is through our federal system. And that's how things acquire the momentum to eventually become maybe a constitutional right, or maybe just become generally accepted even though they're not a constitutional right, like the prohibition on discrimination against the disabled was. But you need the states on all of those issues. And if the federal government is able to just shut off debate and make it really difficult for courts for particular states to go their own way on these questions, then that's going to be a lot more difficult. And so I think it's tremendously important to preserve limits on national power to facilitate that sort of experimentation and debate at the state level, on a whole host of issues.
By the way, you now see why he's the client and I'm the outside counsel.
Let me just agree with Ernie on that and detail some of the issues that we're facing that he's talking about. First, we've got this issue of public school racial segregation, right? We've also got this question of racial intermarriage. We've got this question of discrimination against women in a variety of contexts by state governments. Right? And the glory of our federalism is that we're going to let those issues continue to percolate and let states go their own way until we've reached a national consensus. And at that time, and only at that time, the Supreme Court of the United States will tell us what our rights are.
I think those all came out fine, but I'm really worried about the environment. I'm worried about whether California will be able to have a policy on global warming when the federal government fails to do so. I'm worried about various issues in education. There's a lot of questions I'm concerned about, and that I want to have state debate on. And so I think preserving the federal system is important in a case like this.
Well, I think we have reached a consensus, and I want to thank all of our guests for being here, and I want to thank all of you, particularly given the time of day. So thank you all very much.